Bismillahirrahmanirrahim. Thank you for inviting me and seeking my input. As this panel discussion is in relation to the CPAC,
Yes, absolutely.
in relation to the CPAC and dispute resolution within the framework of CPAC. First, we have to understand what is the legal structure and legal metrics of CPAC and the legal framework under which it operates. In 2013, Pakistan and China entered
Yes.
into a long-term project that envisaged CPAC, and there are a lot of constitutional challenge that have been faced by the CPAC since its very inception, 2013. Some of the challenges. CPAC is a component of a larger project of Belt and Road Initiative. And CPAC is one of the 6 corridors, economic corridors, and Pakistan is part of CPAC exclusively, but there are 6 corridors that connects China throughout the world. And the legal framework is comprised of a 2013 agreement signed by the Pakistan and China. And there is a long-term plan that was executed in 2017. It comprised of series of the project agreements, special economic zone. On the basis of this matrix, Special Economic Zone Act 2012 was executed. Then there is a energy cooperation framework. Gwadar Port project is there, Karakoram Highway, railway project, energy project. I don't want to highlight the details of those projects, but these are the projects, and all these economic and mega projects entails complexities of issues. And one of the issues is dispute resolution. And that is the key component on which we have come in. China has signed almost 65 bilateral agreements based on the CPAC projects. And each bilateral project has one of the standard clause like bilateral treaties, the dispute resolution. It has no specific framework of dispute resolution. Number of disputes have arisen which have been settled on a state-to-state basis. But there is no mechanism where inter-party and interstate dispute are to be resolved. It is not a simple state-to-state agreement, but it involves lot of inter-parties. Number of foreigners are interested, investing, and they want the security of their investment. And what from my own personal experience, what I have gained on the bench, and as a student of jurisprudence and dispute resolution, I had the chance of visiting the IFC, Dubai International Financial Court. That was for myself and for most of the audience and new emerging lawyers, it may be a very good experience that it is an out-of-the-box solution. It is offshore court within the territorial bound of a limitation of a court. Again, the IFC was established in 2004. It has no international or legislative backing. But fortunately, just like New York Convention 1958, which has given recognition to arbitration, now foreign arbitration enforcement award implementation in Pakistan is possible through 2011 Act. Likewise, 2015, choice of court. Now, this is very important for all the audience to understand. 2015, choice of court convention has been enforced, where the choice of court is given. Otherwise, under the Contract Act, Pakistani litigant has no option to go out of the court, and cause of action, if accrues in Pakistan, party could enforce their right under the laws of Pakistan. But choice of the court, if this convention is signed by the Pakistan, then perhaps the parties may select court of any jurisdiction having international courts to go there to have independent judges of their own choice and get a dispute resolved. This is what I want to avail of this facility of addressing this August House to propound that the Pakistan should also establish International Financial Court. It is DIFC. Not only DIFC, earlier it was without a legal framework, now it is under a international legal framework. Just like NEO Convention, Hague Convention of enforcement of foreign judgments have been made possible in respective jurisdiction wherever it is possible. Therefore, there are number of measures that could be taken, multi-tiers, jurisdictional issue. Singapore has resolved this issue by incorporating within their own municipal legal limits. Supreme Court has formed International Financial Court, where they can borrow judges from international jurisdiction to have semblance and give confidence to the public that they are independent, they can have dispute resolved without raising any issue of bias or prejudice on any. If a litigant is a Pakistani litigant is involved, foreigner may say the Pakistani judges in Pakistani court may be biased towards the Pakistani investors. This international court gives you a platform where you can borrow judges from other jurisdiction, give them the confidence and have a dispute resolved. Now, recognition of the international jurisdiction recently in 2019, another convention is in place that is recognition of those judgments, just like New York Convention 1958, 2019, but it will come in force in September 2023. I would impress if at all any government functionaries is present or judges are here, they can consider these 3-4 international convention and mediation. Earlier there was only arbitration that was internationally recognized and enforceable. Now, as Martin Liu has pointed out, there is a Singapore Convention. Pakistan is not signatory to either of it. And I was just discussing during the course of this interaction, one of the judges from the Sindh High Court, few judges of the Sindh High Court said, Karachi is the hub of business and commercial activity. We don't have any commercial, independent, unbiased and confidence-inspiring judicial commercial court. And this is where we must emphasize, and I would impress this conference to pass a resolution or a comment that we should have an international court platform for resolution of a dispute. Number of disputes have been resolved under the CPAC in a bilateral manner. Some of the disputes have landed in court. I don't want to name them. It will again consume a lot of time, but I have some of the details that litigation is pending in court and it has impeded the projects and added tremendous cost to the project. And that is not feasible unless we have a confidence-inspiring judicial system, out-of-the-box solution, international court with international judges. And then we'll have an opportunity to be part of the international platforms as well. It is not that we borrow the judges. Our judges will be borrowed by other jurisdictions. And 7 corridors should have at least 7 international courts along its line. In Pakistan, CPAC should have one of its international court under the aegis of the CPAC in Pakistan as well.
Can I ask you, I understand that you had some comments to make about the introduction of financial courts and commercial courts in Pakistan. Would you like to make some comments about this now to our audience about the introduction of financial and commercial courts? How relevant they can be, for example, for the CPEC contracts in general?
In CPEC in general, China has, I had a chance to visit China, and there is, it will certainly educate our brothers and the legal fraternity. The China has also established international financial courts in Beijing, in Shanghai, in Xinjiang, and not only International Financial Court. I must say, we are today clogged with litigation, and what we are required that litigants are forced to appear in court. I've seen personally myself a litigant sitting in his car traveling on a highway on a WeChat addressing a court about a dispute resolution and giving evidence while traveling on road WeChat, and the court grandeur has reduced into a box court. I have seen only 2 judges, 1 associate sitting here, no counsel before the court. It was an empty court. I was thinking that it is just a mock court, but it was an internet court. International internet court. The litigant in other continent, other litigant in another continent, and they were addressing the court as if we are sitting across. These are innovative ideas. And we have to come out with these innovative ideas in the testing time. We cannot afford wasting time in litigation and raising cost of the projects. And Pakistan should venture into international court, and we are lagging much behind. What to talk of conventional court, we are even not up to mark as regard the conventional court is concerned. But a young lot of judges, lawyers must emphasize and advocate these innovative ideas.
Thank you.